Hi there, everybody. It's Aaron Louws, and I'm here today joined by Nathan Cecil from Holding Redlich, who is an expert in the space of transport, shipping, and logistics law. Nathan, how are you today?
I'm wonderful, thank you. Thank you for having me.
That's all right, mate. Look, the reason I've got you here today is I want to talk about a milestone determination for heavy vehicle national law. Happened on the 23rd of January, and it gives everyone in the supply chain really an insight into how the law can be applied in some truly serious instances. But before I go into the outcome of the case, can you give me a summary of the case that we're talking about?
Yeah, absolutely. So it's part of a series of cases that's sort of given birth to a series of cases across New South Wales and Victoria. It arose out of a very tragic accident on the Eastern Freeway in Melbourne, where four police officers, had pulled over a speeding Porsche. They were in the emergency lane on the side of the freeway when an oncoming truck left the drive lane and collided with those waiting vehicles, and very tragically, the four officers died. So the driver was subsequently found to have been substantially impaired by illicit drugs and fatigue at the time of the accident, and that was obviously two very key factors which led to the crash. As you'd expect, a very substantial investigation followed this, as a result of which it was alleged that the driver's employer wasn't properly managing fatigue within the organisation, and that was the key or root cause of this incident. So following that, a number of charges were brought against a number of parties. So first off, of course, the driver was charged with culpable driving causing death. The transport company was charged with a Category 1 offence under the Heavy Vehicle National Law for failing to discharge its primary safety duty, most relevantly relating to fatigue management of its drivers. Two of the executives were charged, so for failing to exercise due diligence to ensure the company was doing the right thing. The immediate supervisor of the driver was also charged, initially with manslaughter. That charge was later downgraded, and he now faces a Category 1 offence under the Heavy Vehicle National Law. And then the final one, and the decision which has just come out, was the National Operations Manager of the transport company was also charged. Again, that was a Category 1 offence for failing to comply with his primary safety duty as an operator.
So they've been charged. What have been the actual outcomes of those investigations, prosecutions?
Yep. So all but one have reached a conclusion. So first up, the driver at the time was sentenced to 18 years and 6 months in prison. The transport company was fined $2.8 million, which was a near record fine. That was discounted a little bit because they pleaded guilty early, so that was discounted down to $2.3 million. They also received a prohibition order, so that was prohibiting that company from engaging in transport companies for a period of 12 months. So effectively, that company is now just on the shelf and not operating. The two executives, one was fined $70,000 and ordered to pay $60,000 in prosecution legal costs. The other executive, who was the managing director, fined $22,500. He was also subject to what's known as a supervisory intervention order. So that's an order that he has to undertake further education in the areas of fatigue management and discharging his duties. The immediate supervisor of the driver is still awaiting sentencing down in Victoria. And then the case that was delivered the other day, National Operations Manager, he was in the end sentenced to 3 years imprisonment with a non-parole period of 12 months. So he'll serve at least 12 months in jail and is then eligible for release. When he comes out, he'll be subject to a prohibition order that prohibits him from engaging in the management of a transport company. He'll be permitted to drive, but not to manage or to monitor and be responsible for drivers and their rostering. And in addition to that, he had to pay $123,000 in prosecution legal costs.
And is this the first time that an individual has been prosecuted under a Category 1 offence for heavy vehicle national law?
Yeah, almost. So there's been a large number, around 40 primary duty prosecutions so far. There has been only one Category 1 conviction against an individual. And the circumstances of that case are quite different to the one that we've got here. Now, if you compare that to this case, where the defendant was not the owner and operator of the business, he was an employee, he was the National Operations Manager, so he's really down the hierarchy within the business. And then we had breaches over a period of 7 months. So these drivers were being permitted to drive in excess of their work and rest hours, and they were falsifying records for a period of 7 months. It wasn't just one day. Related to all 15 trucks that the defendant was operating down in Victoria, and it related to every single driver in the Victorian depot. And then the case is also groundbreaking for another few reasons. So in the past, we've seen allocators get prosecuted as schedulers. So schedulers are parties in the chain. But in this case, the National Ops Manager wasn't directly responsible for scheduling and rostering the drivers. So he wasn't prosecuted as a scheduler, which is what we have seen in the past. Rather, he was prosecuted as an operator of the heavy vehicle. Now, an operator is described as a person responsible for controlling or directing the use of a heavy vehicle, and there's no case law on what that means. And up to now, we'd probably thought that the operator is more like the owner-driver, or perhaps it's the company that owns and operates a fleet. We haven't really thought the operator is going to be an individual within the management of the organisation. So the case makes new law there. And also the court held that an operator could be someone like the immediate manager or supervisor of a driver. So it could just be your immediate manager up from the driver, or it could be someone in senior management who had ultimate responsibility for the use and control of the vehicle. So that was a big change.
So operator, not executive.
Yeah, well, he was also charged as an executive. So the way that the prosecution usually works is they bring their key charge, their primary charge, the more serious one, and then they bring an alternative, sort of like a fallback. So he was charged as an executive for breach of his executive duty of due diligence. And that's a little bit groundbreaking too, because the company obviously had statutory directors who are executives. It had a managing director who is someone that's obviously very senior, and this guy sat below that as the National Ops Manager. So up to now, there's been a question of how deep that definition of executive goes within a business. So it is the statutory directors or someone who is concerned in or takes part in the management of a corporation.
Now, I know in this case, it was a transport company that was involved and he was an employee of a transport company. Does this case tell us anything about how heavy vehicle national law might apply to off-road parties, people who might not operate trucks?
Yeah, it does. It's really common for, I guess, off-road parties to dismiss these on-road cases, and they say, well, that's not me, it doesn't apply to me. There's always lessons for off-road parties as well, and this case is no different. So the biggest lesson for me was that the court acknowledged that this transport operator did have in place good COR policies, systems, including a comprehensive COR manual. They did have in place accreditation across all modules of the NHVR scheme, including in fatigue. They complied with external auditing requirements, and by and large, they implemented or acted on the auditor's recommendations. And then they engaged external experts to help them design that system and to make sure that it was functioning properly, or at least that it had all the elements that it should have. So this all sounds really good and positive and proactive, which is what we want to see. So you might ask, well, what went wrong? And this is what the judge found. He observed that the policies and systems were not enforced or adequately implemented or adapted. So there were multiple examples of non-compliance with many aspects such as recruitment, screening, driver training, drug testing, work rest hours recording, and work rest hours compliance. So despite the fact that the company had in place the systems and the frameworks and the policies and the procedures, the rubber really never hit the road in those areas. So the great failing was the company wasn't actually implementing, monitoring, and ensuring that those policies were being effective. And that is one of the most common things we see when people get prosecuted or investigated. They usually have done the pre-work in setting up those systems, and that's really good work, but without making sure that that is living and breathing within your organisation, it's being understood, it's being implemented, it's being effective, it's almost like that good work counts for nothing.
Well, and that's why it was a Category 1 offence, right? That's reckless to a risk. So the National Operations Manager at some point has made a decision to not follow some of the processes and procedures they have, and perhaps ignore or not follow through to the extent that he should have some things that were being raised by the company.
Yeah, absolutely. And the third element that sort of came out, which is of relevance to off-road parties, relates to that as well. So that was that at some point in time, the customers of the transport company had actually raised fatigue performance with the transport operator. So initially it started as them complaining about the time that jobs were taking to be performed, and then it kind of morphed into them observing for how long drivers were rostered on and when they were reappearing back at their site. And it led to the customer raising with the transport operator that they've got a concern about work and rest hours compliance. And they said, if we observe this happening again, there's going to be a performance management issue here between us, and there's obviously consequences for you. So that sort of reflects what me and LSS CoRsafe have been saying for years, which is that customers and off-road parties do have that obligation to look out for observable problems, and when they see them, to engage with their transport partners and make sure that they get assurance that those problems are being dealt with. If the customer in this case hadn't done that in the light of or in the face of very obvious problems, we might have seen them being investigated and prosecuted as well.
I take a bit of a tangent here because one of the other things that I wanted to talk to you about was an announcement that the heavy vehicle regulator made December last year, so 2023, and that was the announcement around the off-road investigation team. Is that announcement an indicator that this type of investigation against off-road parties might increase?
It probably is, and it's no great surprise, I suppose, because that whole concept of parties up and down the chain, including on-road and off-road, are part of the chain. It's the whole underpinning principle of the chain of responsibility. The NHVR has said that their priority is to ensure that everyone who works with heavy vehicles, including the parties who contract with transport operators, are accountable for safety. And what they're particularly focusing on for those off-road parties is going to be dangerous commercial pressures or safety practices arising from their business operations. So that's what they're going to focus on. It suggests, at least to me, that the NHVR probably thinks that in the area of off-road parties, there's some more work to be done. And it may be more in the education process and the leading the horse to water process. And that may be the approach they take in their investigations. It will likely result in some prosecutions of off-road parties or more prosecutions of off-road parties as well. But the NHVR has said that they tend to focus on education and bringing you along for the ride if they can. It's the people who won't get the message that they take to court.
Yeah. And one of the other things that I wanted to bring up here as well is something that seems to be on the tongues of everyone talking about heavy vehicle national law in the last year, which is HVNL 2.0, the review of the master code. Does any of that change what we've spoken about today?
None of it changes what we've spoken about today or for the foreseeable future. So without being too much of a wet blanket, those reviews will take time. That's been shown in the past. So we will have notice if and when the law changes or if and when the requirements change and plenty of time to implement those changes. I can't see there being any great change to the primary safety duty and to the executive's duties, which is really what these cases discussed.
Lots happening in this space. Thanks very much for your time and insights, Nathan.
It's been a pleasure. Thank you.